Hudson Valley Property Owners versus City of Kingston. Oh, did I miss one?
Not last.
Oh, it's not the last. Next one. I'm rushing ahead.
Good afternoon, Your Honors. May I reserve 8 minutes for rebuttal?
8
Yes.
is a lot, but if that's the way...
5 minutes then, Your Honors?
Why don't we take 5?
May it please the Court, I am Magda Cruz of the firm Belkin Burden Goldman for the appellants. The vacancy survey conducted by the City of Kingston in 2022 was a deeply flawed, patently unreasonable, and not sufficient to declare a housing emergency under the ETPA. Kingston's methodology and process here.
So what is our standard of review for thinking about that?
Very clearly, this court has held in Spring Valley versus Marrero that a vacancy survey conducted to determine whether there should be rent regulation in a municipality has to be a good faith study. It has to be based on precise data, and it must cover a substantial majority of the building complexes. This court has also held...
So do we make that determination de novo, or do we look to see whether or not there was enough record evidence for the court below to make that determination?
I would submit that you look at if the record evidence indicates that there is enough evidence to establish that criteria.
I'm sorry, so you're saying we make our own factual determination about that?
No, you determine what the record evidence shows if it supports the standard in Spring Valley.
But is that a de novo determination, or are we simply looking for any record support?
I think that you need to do a record support analysis, and in this case, there should be no presumption that what was done by the legislature here, by the government, City of Kingston, there is no presumption of validity according to the holding in Spring Valley, because the ETPA requires the municipality to make a particular factual finding as a predicate to declare the housing emergency. And here, that particular factual finding is a vacancy rate of 5% or less.
Let me try the question one more time. We're reviewing the appellate division's decision, right?
Yes.
So how should we review that decision? That is, if the appellate division has made findings, is what we're asking, is there any evidence from which those findings could be supported, or are we asking something different?
I think that the appellate division's findings, as I outlined in my brief, have numerous errors in them. And when there has been a demonstration that there is a conflict between what the record shows, and we have demonstrated that.
Does that mean you're arguing there's no record support for their conclusion?
There's, correct, there is no record support for the conclusion by the appellate division. And the Supreme Court as well indicated that there were errors. We indicated that there were substantial errors.
So when you say conflict, you don't mean that some evidence points in one direction and other evidence points in another. You're saying that there are aspects of the findings here that are totally unsupported by record evidence.
Yes.
And,
yes,
and
Your Honor.
specifically, can you just enumerate so it's easier to find them?
I will indicate to you that the most significant errors here was that the survey that the city conducted included hundreds of units that could not have been subject to the ETPA. It excluded scores of others that should have been included. It suppressed...
Is that in part because the owners didn't want to participate?
Absolutely not, Your Honor. There is no evidence of that in this record. And in fact, there would have been no incentive for the owners not to participate had they been given a fair opportunity.
They were directed not to participate. So
Excuse me?
I thought there was evidence that they were directed not to participate,
Absolutely
so they
not.
must have thought there's some value in not participating.
No, not on this record, Your Honor.
It seems to me the points you're making go to the methodology as opposed, okay.
Yes.
So you're attack is on the methodology, not on the specific determinations that there were X or Y responses.
The methodologies led to the inaccurate results by the city.
Are you saying that the specific, the return numbers were inaccurate? In other words, are you saying it was 22 instead of 20 or whatever the number might be?
Right.
Or that is not a good faith assessment of the state of affairs? I thought it was the latter.
It is.
Okay.
It was not a good faith
And
assessment.
so then if we conclude that there is some record support for the methodology, then we should affirm, and if we think there's no record support for the methodology, we should reverse?
No, I think that you need to examine the methodology, that on the one hand, the city said it was going to do the
But
survey in a
just
certain way, and in fact, it did not.
To go back to your exchange with the chief, I thought you said that the standard was there record support?
Yes.
Okay, and so if the question
For
is...
purposes of reviewing.
For us?
Question, yes.
Yes. And so if the question is whether the methodology was a good faith methodology, and we find that there is record support for the conclusion that it was a good faith methodology, then I assume we should affirm, and conversely, if we find there was not record support for it being a good faith methodology, we should reverse.
I submit that if the court determines, and that we have presented evidence to support this argument, that the methodology itself that was applied was not a good faith methodology, and therefore the record evidence that was presented shows, in fact, that the methodology was inaccurate, flawed, and led to a vacancy rate that could not be supported under the legal standard of Spring Valley, then this court must reverse.
On Spring Valley, I believe the decision from this court was very brief, yes? A memorandum decision.
It was fairly brief, yes.
Okay, and I don't think that this court recites the details in terms of the standard that the appellate division recites that you would have us adopt. But I take it you don't think we're bound by the appellate division's recitation in Spring Valley, simply by what the only precedent from this court is what's in that memorandum opinion.
Yes, but if I understand you correctly, you're referring to the appellate division in this case, in the
No,
third...
no,
oh,
what I'm
the
saying
appellate
is
division in
in Spring Valley, which is where I think the more detailed examination of the, okay.
Yes.
So part of what I'm puzzling about is, I think before us, we have both an Article 78 and a declaratory judgment. Is that
Yes.
right? Okay.
Yes.
So generally with the Article 78, one of the things we look at is whether the decision was arbitrary and capricious.
Right.
Declaratory judgment may present a different kind of inquiry. So what do we make of the presence of both of those causes of action here and how that affects our standard of review?
I think that this court should look at this from an arbitrary and capricious standard, and whether the decision by the city of Kingston, whether the
But I thought
declaration
you just
was
said
rational or
the
not.
question was whether there was record support, which I
As
think...
well. I mean, all of that, it's intertwined, Your Honor. Something has to be arbitrary and capricious if there is no record support for the decision. And that is what we submit, that in fact, when the city of Kingston determined the vacancy rate to be 1.57%, it had committed material errors that rendered that conclusion to be unreliable, contrary to law, and could not be sustained under the Spring Valley standard, as I indicated. And I was enumerating for you the types of errors. As I said, the city of Kingston, in doing its survey, included hundreds of units that could not be subject to the ETPA. It excluded.
Isn't it true that even if they put back in the units where the assumption of non-vacancy was applied, that it still would have been under 5%?
No, I think what you are referring to is their concession that there were at least 5 buildings for which they did not receive a survey response, and that if they included those units, that doing their calculation, it would still be less than 5%. That's not what I am saying. I am saying that there were hundreds of units that were considered that could not be subject to the ETPA. Units and, well, buildings in that were subject to the Michelama program, buildings that were constructed or substantially rehabilitated after 1974, and even a building that had a vacate order that could not be considered subject to this survey. City considered hundreds of those units. It also failed.
Do we know if in that subset of units that you say should not have been considered, what the vacancy rate was compared to the vacancy rate in the buildings that should have been considered? We don't know that.
Well, I know that it consisted of approximately 20% of all of the buildings that was in the.
Right, but if the vacancy rate were the same, it would make no difference.
When you combine that error and the error of excluding scores of others.
I just want to stick with my question if I can
Well,
for a
just
second.
with, I have not done that math, but.
No, I'm sorry, I'm asking if there's anything in the record, whether you've done the math or not, if there's anything in the record that shows what the vacancy rate was for the buildings you say should not have been included but were.
I can say that those were very large buildings, for the most part.
That's a different issue. You've
Yeah,
already told me it's 20%. I'm not
Yeah, it
asking
was
about its,
20%.
I'm not asking about its relation in size
How
of
many
number of units. There's a vacancy rate for the units that you say should have been included.
Right,
And there's a vacancy rate for the units that you say should not have been concluded.
right.
Do you know is there anything in the record that would show us whether those two vacancy rates are different? Because if they're exactly the same,
Yeah.
the error you're claiming doesn't make any
Yeah.
difference.
You know, I believe that, yes, that they would come out differently.
No, I'm sorry. Is there anything in the record from which we can tell that?
When the city, well, we had requested under FOIL for a spreadsheet with all the information that the city used to reach its conclusion, and in that spreadsheet, and then that is in the record, you have an itemization of the surveys, what the city says those surveys reflect, and that's how they do their math. So in other words, the city, looking at those buildings and looking at the numbers that they calculate, you can derive a number by excluding buildings that should not have been included in the survey, but in fact were included. And in doing so, Your Honors, in combination with the other errors, which also are very material, most notably was the fact that even of the responses that they did receive, in many instances, those responses were not accurately recorded. So, for example, I outlined in the brief at least 5 buildings that had vacancies, and yet the survey data that the city recorded indicated that those buildings had no vacancies, that there were zero vacancies in the building, and that was not accurate. And most material was because they only received 19 surveys from 64 that were sent. They excluded over 45 buildings. 45 buildings were deemed by the city to have 0 vacancies to be fully occupied, and yet that could not have been accurate. And the reason that occurred, Your Honors, why, and going back to what Justice Rivera had asked before about owners not responding, they were given 9 business days by this surveyor to respond to the survey. It is not surprising that there would have been a high number of owners that did not submit the survey response within that 9-day.
Well, there were also follow-up calls and so forth.
There were allegedly 6 follow-up calls, Your Honor, yet 45 buildings never answered. And of the 6, we submitted affidavits from each of the owners saying those calls did not occur. When you have,
Let's say we disagree with you. When would be the next time that there's an opportunity to determine what the vacancy rate is?
you mean when does the city have to do another survey? They're actually involved in that process right now. They have to conduct another survey within 3 years. And so they are engaged in that right now. But it is critical that the standard for conducting these surveys be clarified by the court, because it is not just Kingston that is engaged in this exercise. Across the state, after the HSTPA was amended, now all municipalities in the state of New York can engage in this exercise. And if they're not given clear standards for determining what is the proper way to conduct a vacancy survey, it cannot just simply be, a good faith effort. So that the results are fairly debatable, as my adversaries indicate. It should be a stringent.
I thought it was a good faith study. Are you making a distinction between a good faith effort and the study itself?
I am saying that the study has to be a meaningful one, Your Honor. It has to be based on precise data. It has to be on a review of a substantial majority of the building complexes subject to this. It cannot be a response rate of less than 30%.
I thought we have a factual finding here from below that the survey responses covered 71.7% of the units.
We showed, Your Honor, that was not accurate at all.
Sorry, do we have a factual finding from the lower court as to that effect?
Yes, we do. We do have a
Can
factual
we upset
finding.
that factual finding?
Excuse me?
Do we have the power to upset that factual finding?
When there is a conflict between what, for example, the Supreme Court stated as to one fact, one data point, and then what the appellate division says something differently, and the parties indicate that there is yet record evidence that shows that those factual findings are incorrect, this court has the authority to look at the record and to make that a new determination. I guess that goes to one of the original questions here, a de novo examination. It's in IMO in matter of YK 87 NY 2nd 430, when confronted with inconsistent findings of facts in the court below, this court can review them and choose which findings more nearly comport with the evidence in the record. And to respond specifically to that question, we have evidence in the record that shows there were only 19 buildings that responded to the survey. That means less than a 30% response rate. And I would like to reserve the balance of my time for rebuttal. Thank you.
May it please the court, Barbara Graves Poller for the City of Kingston.
Counsel, do you want to start by addressing the standard for us?
Sure. This court has stated many times, and most powerfully in Albert versus 28 William Street, that an affirmed finding that is supported by any record evidence is beyond the scope of this court's.
Sorry, I mean the question of how we are reviewing the methodology, the good faith study, is that the appropriate standard or something else?
Well, while the study itself, if it were a final administrative determination, would have been subject to a kind of arbitrary and capricious standard, we're not here dealing with an administrative question. This is legislative finding. And the vacancy study was the beginning of that legislative.
But the legislative finding is based upon a vacancy study, right?
Not only, not at all.
What else goes into it?
Well, that's a very important part of the HSTPA. So we begin with the vacancy study, which in this case, as opposed to 2020, alerted our Common Council to the possibility that they may have power to declare
So
an
you
emergency.
think we don't have power to review whether the study was, whatever the metrics are that we would decide whether it's a good faith study, precise data, you think we lack the authority to do that?
Well, I want to be careful in telling this court it doesn't have
I
authority.
don't, no, I'm just asking, you know, I thought that we had indicated that this was a different enterprise than one where there is a legislative finding of fact in the classic sense, because this was a antecedent condition to proceeding.
I guess I see it a little differently, Your Honor, in part because that vacancy report has to be subjected to the other procedures that the HSTPA lays out for our Common Council to follow. And
So if we
specifically,
disagreed and we thought that there was some review that was appropriate by this court with respect to the methodology, is the standard in the Spring Valley Appellate Division and in Executive Towers the right one, or is there something else we should be looking at?
if this court were looking only at the vacancy study, then the good faith effort, common sense approach would be the standard to apply. But the city submits that in this case where we're dealing with a legislative fact finding, where our vacancy study report, which was finalized on June 1st of 2022, was posted for the public before our Common Council began its deliberative process. Then, in accordance with 8623C,
Counsel,
we hold a
that may be true. You may be entitled to some level of deference for determinations made outside the vacancy study, but the vacancy study is part of it, and if that doesn't rise to the level of the standard, which I'm still not sure I fully understand how arbitrary and capricious interplays with the methodology here. But, you know, if the vacancy study were to fail, it seems to me that no amount of deference is going to cure that.
Well, respectfully, it's not just about deference, it's about the fact that that public hearing is a check on the vacancy study
But what do you
itself.
do about the statement, in our opinion, in Spring Valley, that the presumption, you know, that the legislature has investigated and found sufficient facts cannot be applied in a case such as this one, where the implementing legislation requires the antecedent finding?
The way that we understand that is that our Common Council couldn't simply say, we see that our population is changing, we've heard from our constituents, therefore we believe we have authority to declare a housing emergency. They could not simply look at the many New York Times articles that talked about changes in Kingston's population and say, you know what, I heard that from my constituents too. Instead, since this statute has a numeric precondition, we had to deal in numbers.
So suppose you sampled 2 buildings, and you concluded based on that the vacancy rate was under 5%. We wouldn't have authority to review the adequacy of the methodology under your view?
I think in that circumstance, the legislative finding would fail on other grounds, because if a municipality only considered 2 buildings, for example.
What about just on the basis, if you accept all the propositions in that question, including that we found that the vacancy study was legally inadequate, and this is the question I think you were asking, the question I was trying to ask, wouldn't that really be the end of it? We don't have to look at what other factors you considered.
Again, you know, I do want to go back to defending our study, which we stand behind, but in answer to Your Honor's question, I do believe that that requirement under 8623C for a public hearing that almost has a kind of aging requirement built into it. If we have a vacancy study that says just is egregious in its errors, which ours absolutely was not.
Yours is perfect, but assume it's not.
Pretty close. We reached out to 92% of all presumptively eligible property owners. We know that those 92% represent 98.
but we're concerned about.
To the
yeah.
point, Your Honor, if we had that sort of problem, there would be a public hearing record where every property owner who was entitled to notice would come in and say, hold on a second, I didn't hear about this vacancy study, or I have 10 vacancies.
But wait
in
a
my
minute, are
building."
you saying that these parties over here didn't have the right to come into court and bring an Article 78 proceeding to challenge the adequacy of the vacancy study?
I'm not saying that they don't have the right to challenge the legislative finding. They absolutely do, and that's why we're here. But what I'm saying is what would be before this court, and what this court should look at, is what the HSTPA requires. It requires compliance with both a reasonable data collection effort to ascertain the
So
vacancy
what if
rate.
those are oppositional? What if the survey says that the rate is 20% and you have the hearing and you hear from the constituents, and anyone hearing that might say, oh, it's probably 3%. How do you resolve that?
These property owners are very good at advocating for themselves, and they would come in
No,
to
but
the public
let's go
hearing.
with what I get your point there, thank you. Let's go with this hypothetical.
And in your hypothetical, the
Let's say
public,
the property owners did show up. We'll go with what you suggested. And again, anyone reading the transcript or been there would say, that's 3%.
then
How do you-
we would be in
what-
court.
How do you decide what the vacancy rate is and whether or not you can declare the emergency? Survey is 20, hearing from constituents, it sounds like, well, less than 5.
Again, they could come to court, as they did, and the appellate.
No,
and- Oh, sorry.
No,
You're
no.
asking about the good faith
How
effort?
would common council resolve that? That's my point.
You would look at the efforts of the municipality. And the effort of the municipality would be governed by the opportunity to
I
participate.
mean, how would, yes, I understood your point to be, the statute has certain requirements the common council had to follow. It's the survey, it's public hearings, perhaps there's other way to gather information. So my question is, if those things are in contradiction, how would they resolve that?
They being
Or
the,
does that mean that doesn't establish the vacancy rate?
sorry, they being the common council?
Yes, yes.
The common council would have to use its best efforts to maybe gather additional data, or I guess that answers Your Honor's question to a point. If there were some great conflict, or if, for example, at the public hearing, property owners said, we were never surveyed, only 2 received the survey, then perhaps this court would be faced with a different question about the reasonableness of the fact-finding.
But I take it you're arguing that if we disagree with you and think that some scrutiny along the lines of Spring Valley or Executive Towers is appropriate, that your methodology comports with that.
100%.
Okay.
It-
Just one specific question. Do you agree with the state's position that under the regulations, the earliest possible refund would be for a rent paid in August 2020 and not prior to that?
The city has not taken a position on any of the Rent Guidelines Board's guidelines that.
So you don't have a contrary position? Okay.
No, we do not. But again, if, I know my red light is on, but I just want to make a couple of points about the so-called errors that the property owners have raised here. There was no answer to the Chief Judge's question about the impact of inclusions and exclusions. The matter of fact is that we explained in detail why we excluded transiently occupied boarding houses. That's actually consistent with the discussion in Spring Valley, which excluded rooming homes. But the fact of the matter is that housing of last resort is almost always fully occupied. And it actually, if we had included them, our rate would probably be lower. There is also additional evidence in the record, looking at other surveys that found Kingston's rate of vacancy was even lower. At page 620, the American Community Survey found that it was under 1%. I think it's also useful to look at the affidavits that the property owners put in, and not one of them says we needed more time. We submitted data that was not considered, nor do they actually address the vacancy rate at the time we conducted our survey. They say things that are sort of open-ended. Our property usually has a vacancy factor. And so I see my red light is on, and so in closing, I would just like to leave this court with the comments from one of the small building owners. It's on page 171 of the record. One of the owners said, in our open-ended question, is there anything else the city should know? And that owner said, we need to build more housing. And that statement, consistent with our vacancy rate and is consistent with our emergency declaration, and we ask this court to affirm.
Thank you.
Excuse me. Good afternoon, Your Honors. May it please the Court, Sarah Rosenbluth for DHCR and the Kingston Rent Guidelines Board. Assuming the Court reaches the validity of the Board's guidelines, it should affirm. The only issue regarding those guidelines that is properly before the Court is whether the Board's fair market rent guideline is impermissibly retroactive. That
Meaning the other issue, the adjustment, is not properly before the court?
That is our position.
And that's a preservation argument on your part?
Correct.
Okay.
Correct. And I can get there in just a minute, but just to address the fair market rent guideline first, so that issue is actually far narrower than petitioners suggest, as neither the board nor DHCR.
Just to make sure I follow, you mean the 116%?
Correct.
Thanks.
Yes.
And narrower in the sense of the time period it covers?
Yes, and because neither the board nor the DHCR argues that that guideline attaches any consequences to conduct that predated
Your
the
position is
enactment.
it's the DHCR 2 years, correct?
Sorry?
Your position is the DHCR 2 years.
Yes, the DHCR
Yeah,
regulations.
but doesn't that still mean that you would go back to before the emergency declaration is made? Granted, it's after the passage of the state
Correct.
legislation, of course.
Yes, it does, but that is controlled by Freeport-Randall, and Freeport-Randall says you
Why
can do
isn't it
that.
controlled by Regina?
So I just would like to, okay, so Virginia Metro addressed a different question. Virginia Metro addressed whether the HSTPA could be applied to increase an owner's liability to refund rent that was lawfully collected before the enactment of the statute. Whereas here, the question is whether owners can be required to refund rent that was collected before the local effective date, but after the enactment of
But
the statute.
isn't the point before the rent could actually be collected? And if you don't have the emergency, you're not able to
No, because
make a finding regarding that rent.
that specific question was addressed in Freeport-Randall, and that came to a very different conclusion than did Regina Metro. So the facts of Freeport-Randall from 1982 are directly on point here, and that case controls. So
What if you entered a longer-term lease before the effective date of HISPA?
So in that case, we agree that that would be a problem. So our argument is limited to leases that were executed after the effective date of the HSTPA. But yeah, just to go back to.
That position, though, is not entirely consistent with Kingston's position, right? Both in the term of coverage and in lease enter dates lease rent.
With Kingston or with the interveners?
Well, it seems like the lower courts were suggesting that that refund period was longer than the period that you say.
Right, that's the misunderstanding of the lower court that was corrected by the appellate division, because our position is that in no event, and this is very clear under DHCR's regulations, in no event may a refund be ordered more than 2 years prior to the local effective date. So that date here would be August 1st, 2020.
With the lease caveat as well.
Correct, correct.
Is that in the lower court decisions
The caveat,
about lease at the date?
I don't think
leases?
that specific issue was addressed.
And the lease caveat, just so I'm sure.
Yeah.
The lease has to post-date the enactment of HSTPA?
Correct.
So no leases prior to 2019,
Right.
that's when HSTPA.
Right, and so the local, the sort of 2-year, the outer bound of that 2-year period would be August 1st, 2020. So
Right.
assuming a 1-year lease, that would be entered into on August 1st, 2019, so that would be after the enactment of the HSTP.
And so if there was a 2-year lease,
Correct.
I understand you're saying that would not be covered, but what would happen as a practical matter? Would there be some action that was taken and a property owner would have to come in and say, I have a 2-year lease? How does that work?
Sorry, how does what work
Okay,
exactly?
I take it you are saying that a 2-year lease would create a different concern because the
Yes.
lease would have been in effect before the
Yes.
enactment of HISPA, right? And so what is it that prevents the imposition of whatever the amount is to someone with a 2-year lease as opposed to a 1-year lease? How's that distinction actually made operationally?
So I think what you're getting at is that this would take place in the context of adjudicating a fair market rent appeal.
Yes, exactly, yes.
Right, so the tenant would file that fair market rent appeal.
Yeah.
If that tenant had a 2-year lease, then they would not be entitled to refunds of money paid prior to.
So it would get
the local
sorted out in an individualized
Correct.
adjudication
Yes.
when brought by the tenant?
That's right, yes. So, right, so just with respect to that issue, I just want to underscore that Freeport Randall directly controls in Regina Metro does not apply for the reasons I explained. If there are no other questions on that, I would move forward to the next issue, which is the issue of whether the ETPA permits negative rent adjustments in the abstract. And so that issue, we think the appellate division got it right on the merits, but we actually don't think it has been preserved for this court's review. And I would just say that nowhere in their petition, nor at any other point before Supreme Court, did petitioners argue that as a matter of statutory interpretation, the ETPA's reference to the term adjustment precludes downward adjustments. And in fact, when the interveners argued in Supreme Court that the ETPA does permit negative adjustments at page 524 of the record, petitioners responded by calling that argument, quote, irrelevant to the litigation at page 2525, and did not address it on the merits. In any case, we do believe that negative adjustments are indeed consistent with the plain text of the statute.
But what is the purpose of a rent adjustment?
It is to take into account costs and other relevant data that have, that are prevailing in the intervening year, and to set an appropriate level of adjustment for that year.
Off the base rent, which is a fair market value rent, right?
That's right.
So you're really lowering the fair market value if you have a negative adjustment. And how can you do that on an adjustment basis?
No, I don't think that's right. I think that.
My fair market value base rent is $1,000. Now you tell me I can only charge $985. How is my fair
No, so
market
the
value $1,000?
The negative 15% number, I believe, would be adjusted downward from whatever the previous rental agreement specified, not necessarily as adjusted by the fair market rent.
It's not an
guideline.
adjustment to the base rent that was established?
No, I believe that the annual adjustment guideline operates on whatever the last prevailing rent was as agreed to in the rental agreement.
But you have your
Because that's the rent that exceeds what the council believes is the appropriate rent? What would have been the base rent? Is that what you mean?
Okay, so I want to distinguish between the fair market rent guideline on the one hand and the annual adjustment guideline on the other hand. It is true that, okay, so let me just take a step back. So the fair market rent guideline operates to sort of align rents in Kingston with an understanding of what a fair market rent
Right.
is at the time of when they opt into the statute. And then the annual adjustment guideline is sort of a year-over-year.
But when you start, as I understand it
Yeah.
here, people were all operating on their base rent. That's year one, right?
Right, but the base rent, it would be adjusted down to the fair market rent if they take the fair market rent appeal. And
Right,
then,
but
I
let's
mean,
say
yeah.
you don't. Your
Yeah.
$1,000 is your base rent. You take an appeal, you lose. That's your fair market value. Now it's your base rent. Year goes by. Now you go to the adjustment and you say negative 15%. How is that not an adjustment of your fair market value?
No, so I see what you're saying. I'm, to be honest, like not exactly sure how, I have to think about that a little more. But I mean, what I would say.
Rent control, to me,
Yeah.
seems like it's not a fair market value analysis. It's, here's your fair market value. You might be able to increase $200. We're going to limit you to $50 because you're artificially depressing rent to control them. You're resetting fair market value every year by a negative adjustment.
No, the negative adjustment is just, it was the 1 year adjustment.
Right.
It may
And-
have something to do with how close in time the base rent was set and when the adjustment was done, but it does seem, because of the closeness in time and because of the severity of the adjustment, downward adjustment, it goes below what had been established as the fair market
I mean,
value
could New
of the
York
rent.
City say this year's adjustment's minus 50%?
I mean, it would have to depend on the data that they considered. I mean, if
On
it
a case, would it be a case-by-case basis, or could they do it across the board? You looked at the data and the rent, I mean, what data was considered here?
Well, so I want to be clear that that issue is very clearly not before the court.
I understand that argument, but
But there was the statutory data under ETPA 4B was indeed
that fair
considered.
market value had decreased by 15%? What's the basis for a decrease in 15% based on the cost to the landlord?
Well, the rationality of that number is not before the court. We're only talking about whether in the abstract, the concept of a negative rent adjustment is permissible. And I think based on the statutory text.
So under your view, when hypothetically would it be permissible?
I'm sorry. Anytime it's supported by the data.
And what would the data have to show?
It would have to show that costs went down.
My fair market rent is X, right? That's what people are willing to pay. That was what was established. That's my base rent. What costs could go down to decrease my fair market rent?
I mean, theoretically, the cost.
Right.
I mean, theoretically, the cost of fuel could go down as it did during COVID. I mean, any number of costs could go down. Tax rates could go down as they did in some cases in this case. I mean, theoretically, if there was.
Could you apply that across the board if
Well,
tax rates
yes, I
went
mean,
down
that's
in one
how
area?
this is supposed to be done. You are supposed to do it on an across-the-board
So
basis.
doesn't that kind of suggest that going by things like tax rates in certain areas of town doesn't support a negative adjustment to your base rent?
Again, that question would be open for this court to decide in a future case. That's not the case, that's not the issue that's presented here. The question that's presented here, to the extent that it's presented at all, is merely a question of statutory interpretation and whether the word adjustment encompasses adjustments
So,
in either direction.
Whether they could choose a negative number, not the actual number they chose here.
Correct.
If it's preserved.
Correct.
I know your light is on, but do you have a position on the question of the right standard for the emergency declaration?
We believe the Spring Valley standard continues to articulate the correct standard, yes. Unless there are
Thank
further
you.
questions, we ask the court to affirm. Thank you.
Good afternoon, Your Honors. May it please the court, Marcy Kobach, Legal Services of the Hudson Valley for interveners. I'll jump right back to 8629, or Section 9B of the ETPA, which does not use the words fair market value, nor actually the words fair market rent appeal that comes from the regulation. That provides for a tenant to apply for an individual adjustment to the initial legal regulated rent. This relates to the alternative argument we have presented, which, if this court accepted it, could avoid thereby questions of impermissible retroactivity, because ETPA 8626, or Section 6, which I'm more used to the sections, provides that an initial legal regulated rent comes into existence on the local effective date, and then goes on to provide that that amount may be adjusted pursuant to ETPA 9B. Therefore, although my colleague is correct, and the appellate division was correct, that refund orders, if DHCR chose to analyze an individual case that way, could go back 2 years and be constitutionally permissible, that the only thing a rent guidelines board can do is guide DHCR, and the only thing that it can guide DHCR to do is to refund excessive rents paid after the local effective date. The record is replete with spikes in rents at particular times when regulation was being anticipated, in 2019 and in 2022. And it is entirely proper for a regulation to contemplate there may be attempts to thwart its purpose and to account for that in the effective dates and how the regulation operates. Everything the Kingston Rent Guidelines Board did here was in accordance with the purposes of ETPA, which are to prevent hardship and displacement for tenants, which have been found to be legitimate legislative purposes repeatedly by both the Second Circuit and this court.
Thank you.
Thank you, Your Honors.
Your Honors, I'd like to focus on the rent guidelines part of our argument.
Could you first address the preservation point on the adjustment?
Yes, of course. The state is arguing as to the guideline concerning the rent rollback, that somehow we are precluded from arguing about the 4B factors. That's how I understand.
What they're saying is you never raised this issue below, and this court has no jurisdiction to hear it for the first time.
We absolutely raised the statutory violation by the Rent Guidelines Board in our amended petition. We raised it so well,
Do you have
Your
a
Honor, that the
record
Supreme...
site for that?
It's in the, I can provide you
That's
with
okay.
that.
Well, I'll
But
just-
we raised it so well that the Supreme Court annulled the guidelines, finding that they were inappropriate. And then, when the state took a cross appeal from the annulment of the guidelines by the Supreme Court, it was in the appellate division that we fully fleshed out the ETPA 4B argument. And in that context, this court certainly has the ability to review the full range of the arguments concerning the RGB's
The
non-compliance
specific
with
argument about
the ETPA.
The specific argument about the adjustment, where that was raised in the trial court?
It was raised generally as an allegation that the RGB did not comply with the ETPA. However, Your Honor, at the time that the amended petition was filed, we did not have the transcript of the actual RGB proceedings. That transcript was not provided by the state until they answered, and therefore, there was no opportunity to then clearly make those arguments that they did not comply with the 4B.
I'm a little unclear. You're saying until you had the transcript, you didn't know that there was a negative, that they had declared a negative adjustment?
Yes, we brought the amended petition to challenge the rollback, and we did contest it in the amended petition, and we did allege they violated, in enacting that rollback, ETPA provisions. What we did not do is go through the...
What did you describe as the rollback? What's this rollback as you described it?
15%
The adjustment.
rent adjustment,
The-
yes.
the
And we
negative.
also, of course, contested the fair market rent guideline.
Argument as to the adjustment was based on what?
Was mainly based on the ETPA Section 4B noncompliance, that the RGB failed to examine the factors that the ETPA requires in order to set any kind of an
Oh,
adjustment.
so your argument wasn't based on their statutory authorization to do that? You're arguing that they did it incorrectly?
That's correct.
So you agree then with the Attorney General that they could do a downward adjustment?
No.
under-
No.
Then you lost me.
Because you are correct that in the Supreme Court, the two-prong argument, one, that they didn't comply with the factors, and two, that our position is there's no provision in the ETPA for a rollback. That second argument was fleshed out in the appellate
But
division.
in the trial court, your reply brief references page 342 of the record, in laying out where, I'm reading from page 3 of your own reply brief, where you made this argument to the trial court, and I think there that there is, in a header, a statement that decreases at lease renewal are not legal and then a statement that reducing the rent by 15% on renewal is outside the bounds of the ETPA. So is that the full treatment of the legal argument about the authority before the trial court? I take it is, because it's all that's in the reply brief.
I mean, Your Honor, I conceitedly, yes.
I'm just trying to confirm if
Yes,
if I...
it was not fleshed out. However, if you look at our briefing in the appellate division, it's a full briefing, and the appellate division at no point said that we had not preserved the arguments in the Supreme Court.
But we have different rules. in the
Yeah,
appellate.
Understood, Your Honor, but this court, as I also indicated in my reply brief, when the questions deal with statutory construction, this court can and has the authority to review it and make a determination. Because in this instance, where it is so starkly evident that such an extreme, unprecedented act was committed by the Rent Guidelines Board, newly impaneled, to roll back rents, to set a retroactive fair market rent adjustment.
Part of why we have this preservation requirement is we have very limited fact-finding and other authority.
Yes.
So our general view is it's much better for the trial court and then the appellate division to flesh out that record so that we can review those findings.
Understood. But clearly, the Supreme Court found that our presentation was sufficient to invalidate the guidelines at the Supreme Court level.
Can you respond to the argument that Freeport, not Regina, controls?
I submit, Your Honor, that the entire argument about the 2-year limitation on refunding any amount that is in excess of the, quote, fair market rent when a fair market rent appeal is filed, that is missing the point of our argument. We are not contesting DHCR's enforcement of the guideline. We are contesting that the guideline itself, the fair market rent guideline, was retroactive, improper, particularly because the start date and the look-back period goes back to January of 2019, a time when there was no rent regulation in Kingston, a time that predates the HSTPA. Certainly it predates the local effective date, which is when the declaration was made.
It also predates COVID, doesn't it?
It does, Your Honor, but I don't know whether the Guidelines Board was even considering that. And in fact, the ETPA, when it discusses fair market rent guidelines, there's nowhere in the statute that talks about a look-back period. Here again, like the rollback, this RGB just literally invented a new procedure. In the city of New York, where rent stabilization has been in effect since at least 1969, there was an RGB, there has never been a fair market rent guideline established in this manner. And certainly no rollback. It's the first time in the history of stabilization that a rollback was presented to these.
The only question is whether or not they could do it, not whether or not they're the first to do it.
And I know my light is on, and if I may just sum up, Your Honor, that in terms of their ability to do it, I brief for you the many instances in the regulations that talk about increasing the rent as a reflection of the fact that it is not appropriate when you have evidence of rising cost in an inflationary economic environment. How could you logically impose a rent reduction of this form? And as Justice Garcia noted, the inconsistency between having a fair market rent and then immediately directing for a 15% reduction, that is decreasing the fair market rent. It was a totally inconsistent, irrational determination by this Rent Guidelines Board. And like the vacancy survey, Your Honors, we submit neither of those two governmental acts can be affirmed. They are irrational, they are prejudicial, and they are not data-driven. They were determined in a manner contrary to law. Thank you.